6DP. Mr. Burden is here today after failing to appear before referee Snyder on January 3rd, 2024. Bond is currently set at $1,106. This is the second bench warrant. He reports that he is employed by BBB Construction. Last payment made on this account was in September of 2022. Front of the court recommends that a reasonable bond be set in this matter and it be scheduled for hearing on June 5th, 2024 at 8:45 a.m. before this court.
Yeah, thank you. Mr. Burden, you're before the court charged with civil contempt of court due to your failure to appear at a prior hearing as a result of your failure to pay child support. Purpose of this hearing is to set a bond that would assure your attendance at the next hearing on June 5th, 2024 at 8:45 a.m. You will get notice of that in writing. Are you able to post a bond, sir?
No, I'm not, unfortunately. I mean, I can, but I have no money on me right now. I have money at home. I just don't have any way to get a hold of anybody to be able to post a bond.
Okay.
But I was unaware of my last court date. I need to make sure you guys have my correct address on paper, because I mean, that's kind of getting mixed up and I'm getting screwed over because you guys are shipping out these hearings and I'm not getting any of them.
Well, what we're doing is we're sending those to your last known address. If you don't change your last
22,
known address,
is it 22? What's the address you guys have on
I have
record?
no idea because I don't send those out the front of the court.
That probably could be a problem right there then.
when you're get out, what you're going to have to do is go to the front of the court. You're going to have to do a change of address form. And once you do that, then they'll have the correct address, or otherwise they'll just keep sending it to your old address.
Okay.
Well, the court notes in this matter, it's your second bench warrant, so I'm taking that into consideration. But you haven't paid in well over a year and a half. And
I do have money. I have no way to be able to, like, it's in a check in my name, and I was on the way to cash that check when I got arrested. The officer that had arrested me can vouch for that. And I have no way to cash it. Nobody has any way to cash it without my signature, my ID. Like, so I have no way to be able to pay you until I cash that check, unfortunately. But I can, if there's any way I can assure I can get money today for you guys, if I can get out to be able to cash that check to get it to you guys.
That's not going to happen unless you can get somebody to come in. What I'm going to do is I'm going to reduce your bond because it is your second bench warrant. I'm going to set the bond in the amount of $300. If you're able to post that, you'd be able to be released. Do you have any questions?
Oh, no, I do not.
Okay. Thank you. You're free to go. Have a good day.
7DZ. Ms. Hammond is here today after failing to appear before referee Courteau on May 23rd, 2024. Bond is currently set at $1,953. This is the third bench warrant. She reports no employment. Last payment made on this account was in May of 2023. Front of the court recommends that a reasonable bond be set on this matter and it be scheduled for hearing on June 5th, 2024 at 8:00 a.m. before this court.
Ms. Hammond, you're before the court charged with civil contempt of court due to your failure to appear at a prior proceeding as a result of your failure to pay child support. The purpose of this hearing is to set a bond that would assure your attendance at the next hearing on May 5th, 2024 at 8:00 a.m. You will get notice of that in writing. Are you able to post a bond?
I am not, Your Honor. And the failure to appear, I was already in jail, incarcerated in Allegheny County when I had that court date.
Okay. Okay. Well, what we'll do is we'll take care of that at the next hearing on the June 5th date.
Okay.
Court notes that it is your third bench warrant and you haven't paid in over a year in this.
I am trying to go for disability. I can't hold down a job.
Okay. Well, not being able to hold down a job is not a disability.
Well, I have seizures, mental health, and I have a lot of thinking problems. I'm trying, yep. Like I said, disability.
Okay. Well, it is your third bench warrant. You haven't paid in a year, so I'm taking that all into consideration. What I'm going to do is, you do have a sizable arrearage, but I'm going to reduce your bond to the sum of $300. If you're able to post that, you'd be able to be released. Do you have any questions?
No.
Okay. You're free to go. Have a good day.
9 DM. Mr. Manuel is here today after failing to appear before the domestic relations referee on March 3rd, 2023. Bond is currently set at $8,475. This is the 7th bench warrant. He reports no employment. Last payment made on this account was in November of 2023. Front of the court recommends that a reasonable bond be set in this matter and it be scheduled for hearing on June 5th, 2024 at 8:00 a.m. before this court.
Mr. Manuel, you're before the court charged with civil contempt of court due to your failure to appear at a prior proceeding as a result of your failure to pay child support. Purpose of this hearing is to set a bond that would assure your attendance at the next hearing on June 5th, 2024 at 8:00 a.m. You will get notice of that in writing. Are you able to post a bond, sir?
I'm not sure. I should be able to, but I wasn't aware that I thought I was took off and I was just paying arrearages. I'm not sure if I had a job. I don't know if they was taking it out of my checks or whatever, but the building closed down. It went on bankruptcy, so I'm not sure what that's about either. And as far as the not showing up, I did have a change of address. I probably didn't I guess it's my responsibility to show you guys that I changed the address, but I was kind of here and there, so my apologies.
There's no way for us to know what the address is if you don't notify us. Okay,
Right.
well, what I'm gonna do is you do have a considerable rearage in this matter, and it is your 7th bench warrant. What I'm gonna do is, I'm gonna reduce your bond in hopes that you could be released. I'm gonna set your bond in the amount of $1,000. If you're able to post that, you'd be able to be released. Do you have any questions?
Yeah, I can't go lower than that.
Nope. Not when you're looking at an arrearage of approximately just under $40,000. So it's
okay. Well, I thought it was all dropped, and I just had to fill out some papers. Is there anything about that? Like,
well, a couple things you'll have to do is when you get out, you'll have to give the front of the court a change in address, and then you also have to, if the support is ongoing and it's too much, you can always move for a modification of that. But that's up to you. So you're
okay.
free to go. Have a good day, sir.
24 at 9:02 a.m.
Court will note the appearance of Mr. Hilderly on behalf of the plaintiff in this matter. This matter is before the court on the plaintiff's motion for entry of default judgment of custody, parenting time, and support. Mr. Hilderly.
Thank you, Your Honor. Good morning. This is the plaintiff's motion for entry of a default judgment. We did file and serve both the motion and the proposed judgment per the court rule. Defendant was defaulted on April 22nd, 2024. The proposed judgment simply adopts the order which is currently in place pursuant to the court's ruling back in December of last year. We do believe it remains in the best interest of the minor child. The defendant has moved to California presently, and that is where he is currently residing. Both the plaintiff and the minor child remain in Michigan. So we're just asking the court to adopt the default judgment as presented. And I apologize, Your Honor. The judgment was presented to the front of the court and approved by the front of the court.
Okay, thank you. Mr. Miller, do you have any response or reply to the motion?
I am good with that generally. If there's something in there that I have had I don't know whether it's a problem, but it's concern with is that I've been basically unable to interact or communicate in any way with Michelle because of the domestic violence ruling. which means I basically have no contact with, or no means of mentioning anything with Bolt. Shell has been sending messages recently, which is quite nice, but I can't respond in any way.
Okay.
I don't know if there's anything we want to talk about or whether that's just kind of the way that is.
Well, not today. What happens is, again, the matter is for entry of a judgment today. If you have any issues with anything else in the case, you can file a motion, bring it back before the court. The court can then, again, act on and respond to the motion and could change things or not change things. I don't know. It depends on what you'd put in your motion. But at this point, anything that's in place now would have to remain to that point unless you seek to modify it. Okay?
Okay, so basically this court can't touch that one because it's a
Well, we
criminal
can if you file an appropriate motion, but you can't just bring it up verbally at a hearing like this without giving the other side notice and an opportunity to respond. There's a due process right to be able to know what you're going to court over. So,
Oh, okay.
if
Well-
you file an appropriate motion, then it'll be heard at that time. Okay?
That would be through, I would call your court for that.
Well, you don't have to call our court. You can file a motion. Motions are heard again on Monday. We're hearing them today because of the holiday, but they're always heard on Mondays. You would schedule up for 10:30 a.m. and you can ask the court anything you'd want in any particular motion, but you have to provide the plaintiff with appropriate notice, and she has an opportunity to respond then.
Okay.
Okay.
I have asked about this before, and the reason I'm asking you is because I've called multiple people for basically this question.
Okay.
And each one is passing it to the next court.
Well, I'm not passing. I'm telling you what you have to do. You have to file a motion. That's how you get a matter before the court. The motion is whatever the motion is, whatever you want. You can make any request for any relief you want, but you have to state in the motion what the basis is for that. What do you want? Why do you want it? Why do you think you deserve that? And then we'll have a hearing like we're having now, and the other side have opportunity to respond, and then the court will make a decision. So that's what we'll do at this point. The court does find that the court will grant the motion for entry of the default judgment in this particular matter. Court will sign that order. That will then conclude the case. Best of luck to both of you. I hope everything works out for you. You're free to go. Have a good day.
Thank you, Your Honor.
24 at 9:08
Thank you.
a.m.
Court will note the appearance of Mr. Bartell on behalf of the intervening parties. Ms. Reed, are you representing one of the parties?
I'm representing plaintiff Ari Cronkite.
Okay. I didn't have that down with what I had. This matter is before the court on the petitioner's motion for grandparenting time. Mr. Bartell.
Thank you, Your Honor. It was a long motion. I'm not going to rehash everything, but overall, some of the highlights here, Your Honor, is that the petitioner have been heavily involved in the minor child's life since the birth of the minor child. The minor child is 6, should be 7 later this year. She has a very close bond with the maternal grandparents. As this court is intimately aware, defendant mother is incarcerated right now. I would like to point out just a couple things that don't line up with regards to defendant or plaintiff father, I guess I should say, in this matter. You know, we have a plethora of pleadings in the past where plaintiff father routinely, and I don't know if counsel has had the opportunity to review all those pleadings, where he would always say that defendant mother was not truly watching the minor child here, that it was maternal grandparents that were always taking care of the minor child here. And now he does it about face in his response to this petition and says, well, no, they really were not around the minor child that much. No, they weren't really heavily involved with the minor child at all. And I would like to point that out because it's very important in this type of matter, since what this court has to do is determine whether or not it's in the best interest of the minor child, and that there is a very close bond, and that it would be detrimental to the minor child if that minor child didn't have that connection with the maternal grandparents here. It flies in the face of any reason if you have a minor child that is living with practically the maternal grandparents, in this case, having that many overnights as we have alleged in our petition, to not have that be detrimental to the minor child, Your Honor. It's just impossible. And here, Your Honor, overall, we had on average 2-3 plus overnights a week that the maternal grandparents would have with the minor child. And it's interesting. I have a plethora of text messages where, plaintiff's wife would talk about dropping the kid off and I'll pick the kid up later this Sunday and all this stuff. And then they make it seem like, well, no, that never happened, Your Honor. I think what we have to have here, Your Honor, is an evidentiary hearing with regards to this matter. Obviously, there's diametrically opposite views as to what is going on here, but I would suggest to the court that we have to have an evidentiary hearing. I think what has been pled in the petition is sufficient under the statutes to at least get to an evidentiary hearing. But I would also ask, Your Honor, in this particular matter, in the meantime, that this court would be willing to give at least an overnight, even if it's every other week or something, with maternal grandparents with this child. I think there needs to be some type of contact. Plaintiff's wife's only own grandparents on one of her sides do not believe that it would be in the best interest of the minor child to not have contact with the maternal grandparents. They actually believe their own plaintiff's wife is the root of all of this. You're going to have family on the other side coming in to testify against them. And that has always been key in my mind, Your Honor, because when you have family on someone's own side coming in to testify against them, that should really raise a lot of flags as to what's really going on in this particular matter. I believe, Your Honor, that at least in the interim that we have some overnights for the next, even if it's every other week with the maternal grandparents in this matter, I think that would be appropriate. We would ask that an evidentiary hearing be set for this court because this court is intimately aware of this particular case. And unfortunately, I'm sure the court would maybe on some level admit it's sad too, because you've had this from the outset for the last 6 years. And then we can obviously deal with this going forward, Your Honor. Thank you.
Okay, thank you. Ms. Reed, what's your response?
Your Honor, parents have a constitutionally protected right to make decisions regarding their children, and that includes visits with grandparents. The statute and the case law is very clear that they must provide concrete evidence that the denial of grandparenting time creates a substantial risk of harm to the child. And they have not pled that in this case. They only reference it in maybe number 9 of the affidavit that was attached, but there's no expert opinions that are going to come in and provide that information. We have cursory family members that are not qualified to make that opinion. These grandparents have not had contact with this child in at least 6 months. There has not been anything pled that during that 6 months of no contact that this child has been harmed, and there is nothing pled that going forward that this child will have a substantial risk of harm. That is the first step and the presumption that the petitioners have to rebut before we can even get into the best interest factors, and they have yet to do that. Even if they have been deemed to rebut that presumption, this is not in the best interest of this child. The child does not want to see these grandparents. There's a lot of chaos going on because of what's going on with mother coming in and out of the child's life for brief periods of time before she's incarcerated, comes out, goes right back to prison, and then now she hasn't seen these people for 6 months, and now she's going to be forced into overnights, which she doesn't want to do. And then what I see is now that once mom may be released in November, she's wanting to transition right into standard parenting time, which we will be filing a motion to modify because that's contrary to the best interest of this child. So since that constitutional and statutory presumption has not been rebutted, we're requesting that this motion be denied. Further, we're requesting that the request for drug testing be denied, as there's been absolutely no evidence provided that my client is doing drugs, other than petitioners claim that they know he is, similar to that they know that his wife is not on probation when she actually is continuing to be on probation until next year. It's a lot of he said, she said, and that's not enough to rebut this presumption.
Okay, thank you. Well, there's as the court went through the motion, obviously it was quite substantial, and the court notes that the motion did document a substantial involvement of the grandparents with Chloe in this particular case. Whether it's continued for the last 6 months or not, I don't know. That's a matter of evidentiary hearing. But the court does believe that based upon the motion and what's provided in the motion, that there would be a detriment to Chloe's mental or emotional health if in fact the parenting time and contact is not continued. What the court is going to do is grant the motion for grandparenting time. Do it on alternating weekends from Friday at 6 to Sunday at 6, and 2 non-consecutive weeks in the summer up on 30 days notice to the plaintiff. And we'll do that until such time as the defendant would be able to resume her parenting time, or until we have an evidentiary hearing and present other evidence at that point. So that will be the order. Mr. Bartel, you can prepare that and submit under a 7-day notice.
All right, thank you, Your Honor.
Thank you. You're free to go. Have a good day.
All right, you too. Thanks.
At 9:23 a.m.
Court will note the appearance of Mr. Maddaloni on behalf of the plaintiff. This matter is before the court on the plaintiff's motion for temporary custody, parenting time, and support. In this matter, court will note that the defendant has not appeared. It is now 9:23 a.m. The matter was set for 9 o'clock a.m. I do note in reviewing your pleadings, Mr. Maddaloni, that the defendant has not had any contact, and you've not been able to locate Mr. Maddaloni in this matter. And so you're seeking, again, at this point, this temporary custody, or is this for modification at this time?
Well, just to give the court a little edification, Mr. Fields dropped one of the children. They have 4 children together. He dropped off one of the girls to the mother in October of last year and said, you keep her. So she has that young lady with her. He had the other 3 children down in Homer, Michigan. Approximately a month and a half ago, he leaves the children with a friend of his, and he leaves. And no one's heard from him since. Those people down there refused to even allow my client to talk to her children. I told her, just get the police and go get your kids. They have no right to them whatsoever. Those people are in the process of trying to file a guardianship. However, they have no basis for it whatsoever. And again, my advice to my client today after this hearing is go get the police and take your children. She has a judgment of divorce that gives her joint legal custody and allows her to have visitation as agreed by the parties. And since the party that she would be agreeing with is just up and left and not told anyone where he is, I believe my client is the next logical person who should have her children. We are asking the court to grant her temporary physical custody until this gentleman comes back, and then we can duke it out in the court, as the court, would probably prefer to do, to have him here, but he's not here. I don't even believe the people who are trying to get the guardianship know where he is. He just left the kids and took off.
Okay. What the court will do is, again, it does look like the children have been left without proper care or supervision, and the defendant cannot be located. The court will place the children in the plaintiff's temporary care. At this point, the court cannot modify custody without an evidentiary hearing, but the court will place the children with her at this time, pending that evidentiary hearing. So, Mr. Maddaloni, you can prepare an order, submit under 7-day, and we will get that entered at this particular time, and she'll be able to have the care until such time as we can have an evidentiary hearing.
Yes, sir. I'll get that done. Get it out.
Okay. Thank you.
Thank you.
Have a good day.
24 at 9:39 a.m.
Court will note the appearance of Mr. Kelly on behalf of the plaintiff. This matter is before the court on the plaintiff's motion for parenting time. Court will now, it's 9:39. It was set for 9:30. The defendant has not appeared. Mr. Kelly.
Your Honor, we're simply looking to get some parenting time set up. As the court is aware and reviewing our motion, he does have a bond currently in place. It's a $500 PR bond that was put in place in district court over a domestic incident that he is disputing. Unfortunately, it has a no contact provision, so he's unable to contact mom, and she had been, up until recently, not allowing him to see the kids that are 2 years old. So we're simply requesting at this point in time that we can get a set parenting schedule put in place so the children can see their dad. The communication from mom to his family is that they miss their dad. They get excited to see him. They cry at the end of visits. So there's a bond there between father and daughters. Also, he does have a support system in place to assist. He's living with his grandmother. His mom is available. His stepmom and his sister, who are all familiar with the children and have a good relationship with them, are available. So at this time, Your Honor, we're requesting that he get alternate weekend parenting time from Friday at 5 until Sunday at 5. I think at this age, the frequency with which these children have with their mom and dad is important. So during the week, we would request Tuesdays and Thursdays overnight. If the court is unwilling to consider that, we'd at least request Tuesdays and Thursdays from 4 p.m. till 7 p.m. And secondly, Your Honor, in regards to a planned trip that he has with his family up to Cadillac, it's been in place for a while now, and it was going to happen before all this occurred. But he had a planned trip with family up to Cadillac from June 21st to the 25th. He would like to be able to take the children with him during that time. Thank you.
Okay. Well, what the court will do in this matter, the court will grant to the plaintiff standard parenting time, which is alternating weekends from 6 o'clock p.m. on Friday to 6 o'clock p.m. on Sunday, and a midweek from basically the court will do a Wednesday in the event that the parties can't agree otherwise. The court will start the midweek from on June 5th, 2024, from 4 o'clock p.m. until 8 o'clock p.m. The weekends will start on the June 7th date, and then alternating weekends thereafter. The court will grant, and you conclude, or you would have them from the 21st through the 25th for that extended summer parenting time. The court will order that either a relative of the plaintiff or a third party known to the children will provide the transportation in that. But obviously, until that no contact is lifted, he cannot have any contact with the defendant.
His next court date for that, Your Honor, is June 17th. So we're hoping that he can get those bond conditions modified, but we will make sure.
If he does, that's fine. If not, we've got someone in place that can take care of it until such time as he does.
Okay. Could we also consider some sort of, I know with the age of the children, if they have the capabilities of doing possibly FaceTime a couple times a week. I'm not sure how that can be. We'll not bother with that until we get the bond conditions. That's too.
We'll deal with that. We'll deal with that later then.
I'll enter this under the 7-day, Your Honor.
Yes.
Okay.
Okay. Thank you.
1 a.m.
Have a good day. Court will note the appearance of Mr. Verapin on behalf of the plaintiff. Defendants appearing in pro per. This matter is before the court on the plaintiff's motion for temporary suspension of plaintiff's parenting time. Mr. Haley.
Nico ran away from home on the weekend of Mother's Day on that Saturday. And when he ran away, he ended up unscrewing the back door just to get out of the house, which is a very big safety concern on top of the threats of being hit with a belt with metal loopholes in it. And then, so there's all these different safety concerns with the plaintiff's husband threatening Nico nonstop. And then this last weekend, she messaged me during her parenting time within 4 hours of being dropped off, which she was due to have all the way up till Memorial Day, to meet her somewhere. I figured it was for Nico for getting something. Instead, it was dropping Nico off and then leaving without saying what was going on. So my request is parenting time to be suspended for her until things can be figured out.
Okay, thank you. Mr. Farabin?
Good morning, Your Honor. May it please the court. Your Honor, I'd actually like to begin with an objection under MCR 2.119C. Plaintiff was only served with defendant's motion on May 23rd, 2024. I'd ask that the court rule on the procedural objection before I make a substantive response to the motion.
Okay. Mr. Haley, when was service? They're saying that she didn't get served until the 23rd.
I had an attorney that helped me fill this out. She sent it out right away. She said the same day that I was filled it out with the court. And it was personnel mail because that's all they want served with is by mail.
Okay.
The proof of service states May 17th on the ex parte motion to temporarily suspend parenting time to Attorney Reiser.
Okay. Mr. Verapin, it looks like based on the proof of service that you've got proper service. If it was sent out on the 17th, what's your response?
Your Honor, very briefly.
It was sent to Mr. Reiser, so he had it. Obviously, I don't know when your client received it, but he had it.
Very briefly, the proof of service indicates May 17th, and I understand that, but Miss Reiser hasn't been in town since May 15th. I was the person who opened the mail on May 23rd when we received it, and I immediately forwarded it to plaintiff. I didn't have enough time to file a written response to this motion.
Okay. Well, Mr. Haley, obviously it looks like service was proper based upon the proof of service, but from what Mr. Verapin's saying that they haven't had a chance to respond because apparently they got it late or something happened through the mail. So court will put the matter over for 1 week, allow Mr. Verapin to get his answer filed, and then we'll be back next week at the same time at 10 o'clock and we can address it at that time.
Your Honor, I do apologize. I am out of town for 2 weeks in the beginning of June. I can respond substantively now. I just withdraw the objection then, and we can proceed now.
That's fine. Go ahead.
I just wanted to make a note of it for the record, but I do appreciate the court being willing to hear it at this time. Your Honor, my understanding from my client is that the child was asked to do the dishes by her husband on the date of this incident, the weekend, May 10th to May 12th. The child did not want to do the chores and therefore left the house. As we previously indicated on the record, both parties live a short distance away from each other. Plaintiff did previously request a guardian ad litem for this child. And at this time, we are continuing trial on Friday of this week, where defendant is supposed to present his case in chief. For the purpose of the substantive motion, I would just bring to the court's attention MCL 712A.19B3. The termination of parental rights is based on a clear and convincing standard, MCR 3.965C7, that the court must permit frequent parenting time. I understand that there is alleged abuse in this case. My understanding is that there is no screw. No one is shutting the child into the house. It is just a common and frequent occurrence where the child leaves during one of the party's parenting times to go to the other party. This entire case was instituted because the child ran away from the defendant's home to the plaintiff's home. Now it's happened the other way. Lastly, I'd point the court to MCL 712A.13. subsection 8.13, the juvenile's life, physical health, or mental well-being. I would ask the court, what is the risk of harm to both the parties, and what is the risk of harm to the child? My understanding is that the child does not want to do chores. I can see that denying defendant's motion is the right thing to do here, but if the court is hesitant to do that pending the continuance of the case on the 31st, I would ask that the court at least adjourn this out to get a referee recommendation on all issues.
Okay.
Thank you.
Well, the court is, I'm not going to suspend parenting time on a motion without having an opportunity for an evidentiary hearing. But the court would, in the interim, order that the child would engage in counseling. And Mr. Haley, you're going to have to do an order for the counseling, and I'm going to order that the parties would each be responsible for 1/2 the cost of the counseling that's not covered by insurance or otherwise. And then we will set an evidentiary hearing on the motion to suspend parenting time once we've had sufficient counseling take place so we can find out what the issue is. Court would order that each of the parties would contact the counselor, and I guess I'll leave that to you, Mr. Haley, to propose to Mr. Verapin who the counselor is, and see if you can't come to an agreement on the counselor. And if you can, then the court would basically order that the parties would arrange to have the child to the counselor within 30 days of today's date, because I don't want to delay this an extended amount of time.
I have a counseling appointment on the 3rd for him at Summit Point for his regular counselor. Would that be an acceptable one, or?
That would be acceptable through Summit Point. That's so just let Mr. Verapin, let him know what's the counselor's name.
I'm can't remember her name right off because
Okay.
it's a newer counselor, but I can.
After this, let Mr. Verpin know who the name of the counselor is so he can relate that to the plaintiff. And then what happens is apparently you've got that. Let him know again, either by phone message or some other way, let him know when that appointment is again so that he can coordinate that with his client as well. So
All right.
that will be the interim order in this particular matter. And I don't think we'll do anything else today. Anything else, Mr. Haley?
Nope, that'll do it.
Okay, Mr. Verpin?
That's all, Your Honor. Thank you.
Thank you. You're free to go. Have a good day. Court will note that this matter is before the court on the plaintiff's motion to set aside referee recommended order. She stated in her motion that she did not receive the paperwork and therefore she didn't go to court. Court notes I reviewed the file and that hearing before the referee set for February 8, 2024 at 1:45 p.m. was sent out to the plaintiff on January 10, 2024 at the address that appears in the file. That address not your address, Ms. Moore?
I think you said 312 and it's 712.
712. I'm sorry.
Yes, that's my address. Yes.
Okay. Well, that's where it was sent, and then they sent the 7-day notice of presentment on March 8, 2024 to the same address. So you're saying you didn't get any of that paperwork?
I did not receive it. No, sir.
Okay. Well, at this point, I mean, what you have to do is you have to show, to set aside that, you have to show that the referee made a factual or legal error. I don't think that there's any factual or legal error based upon what your objection is. What I'll do, Ms. Moore, is allow you to make further inquiry with the front of the court's office and find out about that. And then if you want to renotice this matter up, you can do that. But at this point, I mean, there's just no basis for the court to.
I talked to them, and she said that my mail, the mail that they was sending out, went to a different address. So she said that it was the correct address, but my mail, even the paperwork that I got, the court order, that went to somebody's complete different address.
Well, I don't know, and there's nothing in your paperwork to demonstrate that to me. You can file a amended petition if you wish, or amended motion, but at this point, I don't have any basis to set aside the referee recommendation. So if you
because that court date, I can't even be heard.
Well, what I'm saying is if you want to modify and redo your motion, so you set forth a basis, but I don't have that now, so I can't grant your relief, but I will allow you to file an amended motion if you wish to do so.
Okay.
Okay?
Yes.
Thank you, Mr. Williams. I don't need anything from you. You're free to go. Have a good day.
Thank you.
24 at 10:36 a.m.
This matter is before the court on the plaintiff's motion to set aside referee recommendation. Ms. Brown, the reason you gave was that you missed the court date. Is that correct?
Yes, I did. I got it mixed up. We're going for child support and for this, and the dates are closed, so I got it mixed up that day.
Okay. Well, let me tell you, is what happens is the court can only set aside the referee recommendation if there's a factual or legal error made by the referee. The fact that you missed the court date is not an error on the part of the referee. So
Is missing a court date enough basis to remove custody of my children?
if you don't come to court, there are consequences to that, and that's unfortunate. But the fact is, we have hearings all the time, and we just can't basically ignore the fact if people don't show up to those hearings. You have to establish factual or legal error by the referee. You have not done that just simply because you missed the court date.
Okay, I'm still in physical custody of the children, so stripping my rights of kids that I'm still responsible for taking care of is making it harder for me to do my job as far as even trying to get them back and forth to school. When I'm getting them to the school building, I'm not even authorized to pick them up, but Justin still left me in full physical custody of the children that I've been stripped of the rights of. Like, I don't know how can I take care of kids where if they need any medical attention, I can't get that, or if they need education, I cannot provide that because I don't have any rights to do that, but yet and still I have full physical custody of them.
It would be no different than if you were a parent and you had parenting time. You have a right to get medical attention during parenting time or to converse with the school, etc.
He's called the school and told them that he's called around, let them know that he has full rights and made it where they cannot speak to me whatsoever, but I still have the children. How can he have custody of someone that he doesn't actually have on his time? I have them 24/7.
Ma'am, there's a statute, it's called MCL 552.30, and that provides for you to have contact with the school, and even as a non-custodial parent, you have a right to converse with the school and get information, etc. So you have a right to do that, regardless if you have custody or not. What happens is there's just not a basis for the court to grant your motion.
So what was the basis to take my children then? I'm so confused. What was the factual or legal basis to take them and give them to him?
You'll have to review the referee recommendation and the opinion that the referee filed, and that will provide you with the basis for that. Okay.
Why was I not provided that at all?
That comes out, that's what you're objecting to, is that particular order. So you did receive that, or you wouldn't.
It didn't have any reason on it. It didn't have anything on it, but it just stated that the kids were removed out of my custody. So I guess my main thing right now is, how do I get my kids back into my custody? Because I have the children, and really Justin only wanted custody because he doesn't want to pay child support, which we're fighting over now. So I'm so confused as to what legal ground did he have to remove children that I've had for almost a decade with no help.
Well, the basis should be contained in his opinion.
Come in that if I miss a court date, I lose my children. I have never heard of CPS even doing something like that. If I miss a meeting with them, they remove my children. I didn't get anything in the mail or any notice stating any legal reasons of why I lost custody of my children.
Well, it would be in the referee opinion. Maybe you didn't receive that or whatever. You can get it. You can look through go to the circuit court clerk's office and then look up the referee opinion. And it will be an opinion and an order, and you can review that. You always have a right to file a motion for change in custody if you wish to do so. And so maybe you're going to have to do that. I don't know. I can't
that's what I thought this was. I'm not here to argue or do any of that. I'm just here to get the custody back of my children. Well, so basically this is all a waste of my time coming back to this court hearing. When it's
a waste of your time, it's a waste of the court time too. You filed.
Okay, well, I'm glad we all wasted our time this morning. That's what I'm basically saying. So what steps? When I went to circuit court, I explained to them what I was trying to do. So they're the ones who guided me.
The clerk can't give you legal advice. They have signs.
No, not advice. I was asking what I needed to file for to get the custody changed back.
To tell you what they have to file for is legal advice, and they can't give you legal advice, and they have signs up to say they can't give you legal advice. So what happens if you want to change the custody, you have to file a motion for change of custody. But based on what's happened, it's limited. I can only set aside the referee order if there's a legal or factual error, which you haven't demonstrated. So
have you reviewed it?
I've reviewed your motion.
No, have you reviewed the referee's order, or is that my job to review?
That's your job.
Oh God! Even though I wasn't provided with that.
Well, you would have been provided because they send that out to everybody that's in the file. So I don't know. I don't know if you've had a change of address, so it didn't go to that.
No, the paper I got just says that the custody was changed over to Justin as of this date. And if I wanted to object it, I had 21 days to file the paperwork that I filed. I filed it. And now it's basically that I don't know, we're at the bottom of nothing again. I just followed what the information said on that paperwork. If you want to review what was sent out to me, nothing on there stated the referee's reasoning for removing the custody. Nothing on there said anything. It just said that the custody was changed.
You're going to have to get a hold of a copy of his opinion, and that you can get through the circuit court clerk's office, and then you can review the opinion if you wish to do so. But
is Justin at court today?
He is not.
Okay, so since he missed court today, why don't they just transfer the kids back over to my custody?
Because
he's been provided.
This is your motion, ma'am. It's your motion to set aside the referee order. Your motion, you have to set forth a legal or factual basis for doing so. You have not done that.
Okay, but I'm asking, since Justin missed court today and he was served papers to be at court today, since he did the same thing I did, which is missed court, why don't they transfer custody back over to me? Because that's how they transferred it to him.
Not the same. It's not the same. That's a different hearing. And there are different, again, parameters for that hearing, different requirements for that hearing, and it's not the same, as I stated.
We didn't have a custody hearing. We had a hearing about truancy about school for the both of us being responsible for that.
I don't know what your hearing was. I simply am here to address your motion, and you don't have a factual or legal basis to do so. So I can't grant you requested relief. You're going to have to file whatever appropriate motion you deem necessary to get the matter back before the court.
So I just have to do my best to figure out what to do, because nobody at the court can tell me what paper or how to go about even filing the right motion. So clearly you're saying I filed the wrong motion. And you're telling me the circuit court can't tell me what motion to file. Nobody in the world can tell me what motion to file to get my kids back.
That's correct. They cannot give you legal advice and to tell you.
I didn't want legal advice. They're the ones who told me to file this motion. They printed the paper out and they said, well, you're going to have to fill this out if this is what you're trying to do. Boom. They gave me the paperwork. So they gave me this paperwork to file with you to get back into court. So how is it that now at this point, they can't tell me what they've already told me? I'm not the one who came up with the idea to file this motion. When I went into circuit court,
you just said they said to you that you have to file this if this is what you want to do. So they didn't say you have to file it. They said if this is what you want to do, and apparently you wanted to do that. And
I wanted to.
That's what you just said, ma'am. So
yes, sir. You're not talking to someone who's incompetent. I went to the court. I explained to them, hey, I missed court and I lost custody of my kids. They said, okay, well, if you want to object that from the referee, this is what you have to fill out.
I'm not going to keep going around and around on this. You have a basis.
I'm trying to get an understanding so I can get.
You have a right to file a motion if you wish to do so, but the motion that you filed does not have any basis for the court to grant your requested relief. I can't just grant it because you want it. There has to be a basis for it, and you haven't done that in the motion that you filed.
Okay, thank you. I hope you guys have a good day. I'm going to come to the court and file something else.